Ms. Gonzalez-Dean, you're the plaintiff. We'll start with you. What is your opening statement?
My opening statement is as follows. Given the circumstances within the past year, I believe it is in the best interest of Valley to be in my care full time, given the unknown circumstances that keep arising, be it domestic assault, drug usage, jail time where she's left alone. I do believe that it is in her best interest to be with me solely.
If you think family court is predictable, think again. Today, a mother asks for full-time custody after a year of chaos. Alleged domestic assaults, drug use, and sudden jail stints leaving a little girl in the crossfire. The father says he's clean, moved to Reed City, and just wants time like he gets with his son. The judge? Already tapping the brakes. Distances, details, and dates matter. And if you didn't subpoena your witness, they're not walking through that door. Stay with me. 3 key incidents, a disputed video of a dangerous pickup, and a new Supreme Court rule about hearing from the child could flip this case.
Okay. Mr. Richardson, what's your opening statement, sir?
My only statement is that I just really wish to see my daughter again. Hopefully we can go back to what we had. Obviously, we're living in Reed City now. I've been clean for a long time now. I set the results in. I had a real epiphany.
How far away do you live from the plaintiff currently?
I live in Reed City now.
And how far away is that from her?
An hour and a half.
How many miles?
Hold on, we're Googling it right now. But
Well, you're not supposed to be getting any information from anyone else in that room.
oh, sorry. I'll Google it right now myself.
Please do.
Hold on. It is it's 59 miles.
Flag this moment. Dad starts Googling mileage mid-hearing and gets corrected for getting help from others in the room. Small thing, not in family court. Judges watch credibility like a hawk. Accuracy, independence, and respect for procedure all feed into how your testimony lands. Also note the numbers, 159 miles, but about an hour of travel time. Those inconsistencies can get exploited later. Engagement cue. If you were the judge, would this minor slip change your confidence in Dad's planning and reliability? Or is it a nothing burger? Drop your take below and tell me whether you think distance should limit overnights during the school year.
Okay. And how far travel time?
1 hour.
Mm-hmm. So what is it you're requesting, sir?
My request is to match the custody time I have for Timothy, where I get him every other weekend and every other week during the summer and everything. I mean,
Okay.
I made some mistakes, but I would like to see my daughter. I've been clean. I've been doing good. I've been going through all
Well, then I would ask Ms. Gonzalez-Jean, since this changes everything, because the initial objection was because they were requesting week on, week off, which was initially ordered but never followed through. Is it appropriate at this time to do every other weekend? And
No. Given the circumstances, it sounds as though he's with the ex that he assaulted numerous times over the past 3 years, where we have an encounter in January where she literally fled the scene. I had to save my daughter. And so
okay. At this point in time, you didn't agree. Therefore, we're going to have to go to proofs. All right. Ms. Gonzalez-Dean, you may call your first witness.
Watch the pivot. Dad backs off the original week on, week off and asks for a standard alternating weekend schedule plus summers, more realistic given the distance and school routine. Mom says no, citing safety and past arrests. The judge immediately moves to proofs. Translation: opening statements are promises. Proofs are evidence. Testimony, exhibits, dates, specifics. In parenting time disputes, courts balance a child's need for both parents with safety, stability, and schooling. Engagement cue: should past arrests, if followed by rehab and clean time, still cap parenting time? Or should there be a graduated plan that increases time as sobriety is proven? Sound off.
My first witness is Elizabeth Hayes.
Okay. Do we have a Miss Hayes here?
No.
Who is Elizabeth Hayes?
She is the friend of court.
Did you subpoena her as I requested?
We had documented and submitted information to the clerk.
No, I told you at the motion that you needed to subpoena witnesses, and the 5th floor of the courthouse could do that. If you did not subpoena them, they will not show up. So she will not be here. They don't just show up. You have to tell them.
Good. And I spoke to her and sent the information to the clerk. That's why I thought that it would be
No. I told you that you had to subpoena the witnesses. Like I said, I rewatched the motion. I was very clear and explicit about how to do this. So who is going to be your witness then?
This is a teachable moment for anyone in family court. The friend of court witness won't appear because she was not subpoenaed. Phone calls and emails aren't enough. You need a formal subpoena so the court can compel attendance. The judge even reminds that he explained this at an earlier motion. Why it matters. In close custody fights, credible third-party witnesses, probation officers, FOC staff, counselors, can corroborate timelines, drug testing, and safety concerns. Lose them, and you're left with he said, she said. Engagement Q. Have you ever seen a case swing because a key witness never showed? Tell us what happened.
I would then call upon myself as a witness. I received
All right.
defendant court motion, everything.
All right, Ms. Gonzalez-Dean, please raise your right hand. All right, since it's obvious that you cannot question yourself, I'll allow you to testify in what's known as the narrative. Please proceed.
The situations over the course of 3 years have increasingly become dangerous to my child, where over the past 2 years, there were 3 incidences where I was called to pretty much rescue her due to unknown circumstances of her father being in jail, incarcerated for breaking PPOs, having over 6 grams of methamphetamine on him, fleeing the police, and again being incarcerated on a Monday where my daughter was expecting to be picked up on that day, only to then have to give her back on that Friday, I believe, because he got out and claimed that he was clean and free. And unfortunately, that just doesn't sound sufficient.
Okay.
When
were those 3 incidents?
There was an incident last year where he was incarcerated for a month and a half.
Approximately when? The question was when. Last year doesn't tell me much.
It was May.
May of 23?
Correct.
And he was incarcerated, according to your testimony, for a month and a half. Is that your testimony?
Are you asking me?
Yes, I'm asking you because I'm trying to clarify what you just said.
That is my testimony in that circumstance.
Mom testifies in a narrative, allowed when you can't question yourself, and lays out 3 anchors. 1. May 2023 incarceration for roughly 6 weeks. To January 2024 alleged assault of dad's ex with the child present. And 3. February 2024 alleged PPO violation and arrest. Notice the judge jump in to pin exact dates, because without dates, incidents blur and lose weight. Family courts often map these events to best interest factors, capacity to provide a safe home, moral fitness, and continuity for the child. Engagement cue. Which of the 3 dates, if proven, would you find most persuasive for limiting overnights right now, and why?
All right, so he was incarcerated for a month and a half last May of 2023.
Correct.
Okay. You listed 3. When is the second one?
That was the one last year. And then there was an incident in January where the ex was assaulted and he fled to work, where I was then called to the scene in Muskegon, as his witness may explain, where I was called to the scene because he had gone to work. The ex was clearly bruised from her hips to her shoulders. Her Xbox or PlayStation had been smashed. My child witnessed all of these things and to this day still mentions moments of fear or acknowledgement of actions that she should not have witnessed. So at that date in January, I was called to the home in Muskegon where I was able to get my daughter. And then I believe we met in February actually, and we talked. I was told that I had to give her back, and unfortunately it wasn't the timing for his days, so we waited until Friday. He received her on a Friday. Saturday, I received a call from him stating that she wanted to talk to me, that she missed me. This was a lie. He wanted me to go to the home that he had the PPO at, get the items that were supposedly his, but that's not my concern. That is not my business. I told him I'm unfortunately not able to do that. So when he called, he pretended that Valerie wanted to talk to me, but she didn't. He just started yelling at me about items that I had no clue where they were. I had no possession of these items. So then after that, he hung up. I was on the call for about a minute and a half, and he hung up. I didn't even get to say goodbye to Valerie. She went to school on Monday. He then broke the PPO, was at the home when Jordan saw him and passed by. She called the cops, who then came, picked him up, and they incarcerated him. After which, his sister called me.
This section is heavy. Mom claims the child witnessed bruising, smashed property, and post-incident panic. Further, she says the ex later reported seeing dad smoke meth at home. While allegations aren't proof, courts treat child exposure to domestic violence as a major risk factor. Fear, hypervigilance, school regression. If the judge believes the child saw assaults or lived amid drug use, expect supervised time to start, plus requirements like substance testing, counseling, and non-contact orders between adults during exchanges. Engagement Q. If you're the judge, do you start with supervised visits or a tight daytime-only schedule with random testing? Vote in the comments.
Because Valerie was at school and she was going to be needing picked up somehow.
Okay,
So
this was then in February?
Correct.
Okay. So we got May of 23, January of 24, and February of 24. Okay, so that clarifies the 3 incidents that you were called to take custody of the child because he was unavailable or unable. Okay, you may proceed. I was trying to clarify times and dates because sometimes people throw that out there and it's like you find out it happened 4 years ago.
Yep, no,
these are all essentially current to the ongoing issue to this day. So I know you filed 2 motions, and unfortunately, reviewing the file at the times they were filed and the ex parte orders, they were insufficient. But that's why we're here, is to fill out the gaps and to substantiate some of this stuff or to figure out what's going on. So you may proceed now that I have the 3 dates and times. And again, sir, you get to cross-examine on these. So please proceed.
What do you? Can I get a brief explanation when you make cross-examine? I gotta wait till she's done, or ask?
Yeah, you wait till she's done, and then you get to cross-examine.
Okay. One last question. Like, can my witness testimony be a cross-examination, or I have to wait till I ask the witness?
You have to wait till you get to call a witness. She gets to call all the witnesses she's going to call. Then you may cross-examine her. Well, you may cross-examine all of her and her witnesses, and then you get to call your own witnesses.
I'm going to have my witness's testimony be the.
Okay, that's fine. We'll get there. We're not there yet. She's presenting her case.
Yep, I know. Thank you for explaining it.
No, well, I tried to explain it the first time we met. Since I don't remember the first 2 times we met, I know there were a couple of motions in front of me earlier this year. Forgive me, I don't remember them. I deal with the issue. I deal with the issues as they're presented to me, and I deal with them piecemeal. So it's now that we get to put it all together a little bit better, hopefully. So that's why I wanted to get that down before you just spewed out 3 incidents, ma'am, without any context or substance of the issue. So now please proceed.
I have one last question for you, sir.
Yes.
I have 2 of my witnesses here with me. Do they need to get on Zoom?
They need to get out of that room. Okay. I need them to testify separately.
They're not with me. They're in another room, but I mean,
okay. They're in another room. They will get on Zoom. They need to get on Zoom themselves. Yeah.
Okay. I'm going to take a quick
we'll give them time when that happens.
Okay.
For right now, we'll continue with where we're at. All right. She's in her case in chief. And once she presents hers, like I said, you'll get to cross-examine her and any witnesses she calls, and then you'll be able to call your own witnesses.
Okay.
All right. And the court may have some questions for all of you, and we'll see what happens at that point. All right, Ms. Gonzalez-Dean, please proceed.
After the incident in February, he was then incarcerated on a Monday and was released on a Wednesday, demanding Valerie back. I at this time said, no, I will not be putting her through this again. That date that I had to pick her up on Monday, I had asked the school to keep her after school because I had set up the after school program for her at my time. But unfortunately, this child is very smart. She understood that if I'm going to the after school program, my father is not picking me up. And she is angry. She is saddened. She misses her father, but she doesn't understand these actions that have occurred within the past 9 months are not safe. The ex that he assaulted over the course of 3.5 years that is documented within the front of court recommendation, as well as a CPS review that had been completed in January and February. She contested that she witnessed Mr. Richardson smoking methamphetamine within the home. She contested that all of these things were done, but being a victim of domestic assault and abuse, you are scared to answer questions that may help you.
Who contested? When you say she, you're talking about your daughter?
No, I'm speaking of Jordan Mansfield, Timothy Richardson's witness.
Okay.
She is the one that called me to the scene in January in order to get my daughter from the trailer, as he had just assaulted her and went to work. And over the course of the few months, we were very close again. As you've known, as I presented in the court cases before, we've gone back and forth where we're able to talk and be on good terms. But then March came around and there was a meeting between myself, Jordan Mansfield, which is the second mother to his child, and his father and stepmother, where they affirmed that he cannot make sound decisions and that they were not sure how to proceed, that they wanted to see Valerie, but unfortunately they couldn't trust that he was not doing what he needed to do. So we did have a meeting March 22nd on a Friday where we hung out at Ravenna Bar, got food, hung out, and then Saturday, Timothy moved in with them. And then the 25th, they had the court proceeding stating that Timothy had already been living with them for months, which is not correct. And I did mention that in a previous proceeding. After March occurred, then May happened. That is when I received the friend of court recommendation. And Jordan herself and I had been communicating as to how the cases were going. I was very scared. There was an incident last year where he moved the car multiple times with my child unbuckled and myself nearby with the door open. I have been very scared of this situation, honestly. I called the cops that day, nothing happened, but the ex was with me on this case until...
What do you mean he moved the car with your child in it?
I had submitted a video where he was coming to pick up Valerie Richardson for a wedding, and he was very rude and disrespectful, was screaming at me. I have video of this as well.
All right, so you say you submitted that, which I'm assuming you're wanting to mark that as an exhibit and enter it at this time? Again, no, the court does not look at this stuff unless a witness is on the witness stand to say what it is. I explained that very expressly.
Sure.
You can send us the emails, and I told you a week beforehand, and nobody sent them to me. We got them yesterday. So I have not looked at them. I've made sure that I can download them. But I don't get
them yesterday.
Yes, I just received them yesterday.
Correct. I believe both of us submitted items.
They all came in yesterday. That's when my clerk received them. So you said you sent a video.
I believe so, with numerous images. I also received them from Timothy as well back on August 14th. We both had submitted all of these images and documentation and photos back in August.
The court received nothing until yesterday. And what the court received, it appears, is what the court received appears to be nothing but emails. How did you send them to the court?
I sent them to the email. I asked in the email where to send them, and they said to send it to the email. So that's what I did.
Yeah, the email only came through yesterday. And all that the court received, from what I glanced at to make sure that I could open them all, the only thing the court received are all text messages. Do you have access to this video, ma'am, that you can bring up on the computer?
Yeah, that's strange. Apologies.
No, I apologize, because if you sent them in, I'm trying to figure out how you sent them in, because
we sent them both in before the deadline.
Correct.
Okay.
That's why.
Well, I'm grateful you did. I'm just trying to figure out why I didn't receive it, because all I've received are copies yesterday of text messages all over the place. And again, I haven't read them. I just opened them to make sure I could open them.
Right. So this incident was April 14th. I had called the cops, but they stated
of this year.
No, 2023.
Key procedural
2023.
nugget.
Okay.
Both
They had
sides say
stated
they
that,
emailed exhibits
unfortunately-
earlier, but the judge explains he can't review materials until the hearing, and as of now, has text messages only. No video files. That's normal. Judges avoid reviewing evidence off the record. Proper practice is to exchange exhibits ahead of time, then move to admit them live with a foundation witness, who recorded it, when, where, whether it's unaltered. The chain matters. Engagement. Q. Do you think body cam or dash cam footage should be automatically
There
pulled
were
in
no
cases
actions
involving kids,
needed
or should it
further,
still be on the
and
parties to bring it?
It was a resolved issue, but I do not agree with that whatsoever. I was very distraught. It was horrifying. I thought Valerie was falling out of the door because she was on the right-hand side unbuckled, and it shouldn't have happened like that. Apologies, I'm still going through right now to find it.
Okay.
But she was unbuckled on the right-hand side. He drove off speeding to the left.
And this was what the video showed.
Correct. It shows very clearly. He stated to the officer that he did not have the door open. He stated that Valerie was safe and buckled, but in the video you can clearly see that she was not.
Okay.
Apologies. It's taking a moment to find that.
Relax. Actually, oddly enough, it's easier to do videos through Zoom. when we do it at the courthouse, generally half the time the media that you try to present is not compatible with the stuff at the IT stuff at the courthouse. So,
Is there?
yeah, no, that's fine. You can do that. It works. Okay. Looks like a road at this point. And of course, Mr. Richardson, you received this, so because you said you did. Okay.
Oh, come on.
Well, I'm glad you have something there to show it. So you exchange this, and
It's taking just a moment. Apologies.
that's okay. You don't need to apologize. Again, we're just trying to get this right. And if you have that ability to show it, great.
This has just been, yeah.
Might take a moment to load.
So my sister had gone through some things with her boyfriend previously. So at the time when things were getting loud, she decided to record, and that's why she was recording.
Oh, so this is your sister's recording?
Correct.
But you were there.
Correct. I'm pictured in the video as he drives off.
Okay. Speaking as one who doesn't have IT work for them very well because of probably my age and user error,
I'm not good at, he was always the good one at technology. I am not good whatsoever. Oh, no.
Mr. Richardson, take a compliment when you can get it.
Thank you very much. I appreciate it.
Yeah, I don't get often that one party will compliment the other, even in the middle of proceedings. So I'll take whatever glue I can get to get you to get along even a little bit.
That's all I want, is just for us to get along. I've changed a new leaf, and I'm really trying. So,
well, you're trying, but there are some questions. You've been arrested a couple times, so and that's a matter of court. I mean, those are things I have to acknowledge.
I made a mistake. So
yeah. Well, and you know, justifiably, I mean, the court can take judicial notice of what was filed in the criminal actions against you. But you know, like you said, you're trying, so we're going to try and move this along from there. The question is how, and how to do it safely for the child.
Yep.
Initially, when we did this, sir, I will admit it sounded like you wanted to go back to week on, week off. I think you've reviewed your current situation appropriately.
Yeah, so, my dad is a very wise man and had a good talk with me and told me, what would work best. And, I won't be able to get her to school every day. So her she can't continue to take her to school.
Yeah, well, the distance is going to be a problem. So,
but I wanted to see her, every other weekend. So.
And the court will mandate that you see her. The question is how and how often, and eventually it will get up to, if it doesn't start the way you want it, it should get up there eventually, as long as it can be done safely. Normalized parenting time should occur. The child needs to know both of you. We just have to make sure it's done safely. I just need to know what the background is and how to start this.
I'm just worried about Miss Gonzalez seeing what happens following the order, because she refused to follow it last time. So
she refused to follow it because it was week on, week off. And for obvious reasons, due to the arrests and the incarcerations, she had some concerns.
No, that's understandable.
Yeah. And then she was protecting the child. Like I said, parenting time is supposed to occur if it can be done safely. The question is, how do we do that? And I need to know how bad it was before I can make or issue an idea of what's going on.
I messed up.
Yeah, I kind of got that from the pleadings and some of the stuff. But the question is, the child's 8, correct?
Yeah.
All right. I may have to meet with her before I issue an opinion, because at this point in time, the Supreme Court has issued a ruling that says I have to meet with a child at least 6 years or older. So we'll finish this, but I will probably not be able to issue a ruling until I meet with your child. I need to take into account her reasonable preference.
That has been something that I've been wanting this whole time.
Well, age is an issue. Normally, we would have never, until about 3 years ago, met with a child under 10. Now the Supreme Court has said any child 6 and older, what the court must meet with.
Oh my gosh,
I got to admit, I've met with 6-year-olds that have not been very helpful.
No, I can imagine.
But I have to do it because that's now the legal mandate.
Sorry, I've got it. It's just taking a second to load.
That's why we were kibitzing until you got it ready.
Critical legal turn. The judge cites a Supreme Court rule requiring the court to meet with any child 6 or older to hear their reasonable preference before ruling. That doesn't mean kids choose, but their view becomes a factor. Translating to this case, an 8-year-old can report feelings about safety, school routines, transitions, and overnights. Judges typically interview in chambers, off the record or on a sealed record, to prevent coaching fallout. Engagement. Should an 8-year-old's preference affect overnights now, or only after stability improves? Parents watching, drop your respectful takes below.
It's saying it's sending and it will be good to watch. It just has to send completely and then I'll be able to click into it to then show that video. And I do apologize if I cry.
Well, I apologize because if you guys both complied with my order and you sent it in last week, I don't know why it's not in my grubby little hands.
That's why I don't understand everything showed yesterday. Yeah,
I mean, I think a whole bunch of police reports and stuff like that too.
As always, I keep checking with my clerk starting about 3 days before a hearing. Did you hear anything? Do you know anything? Do you have anything? And she kept saying, nope, not seen anything, not done anything. And we were at the courthouse this week. Today I'm at home. And so I'm a little bit.
Referee, may I say something?
Oh, okay, certainly. My clerk. Yes.
I've been sending you chats.
Oh, I'm sorry. I didn't see them. No, I haven't received any chats.
Oh, that's odd. Because I've been sending them to you while we've been discussing this.
They just showed up, but they did not register as I was getting
They did send, both of them did send emails to me a month ago.
Oh, okay.
But because you can't look at his exhibits beforehand, I sent it to you yesterday. I thought I made that clear.
Oh, I apologize, but still, what you sent me were all text messages. There are no.
Correct. I did not receive any videos.
Okay, so my clerk did receive them, and she was withholding them. So, and justifiably, because I can't look at them until the hearing, really. But the court did receive, but what the court received was all text messages. So I did not receive any videos. We're still at square one. Relax. We're going to get through this. It's okay.
Am I able to play this now?
Yes, please, if you can, of course. Whoa.
I showed this to the officer and he said there are no further things needed, and he let him go to the wedding and he didn't talk to him. He didn't talk to him or anything. He said he was fine. So I've been dealing with this for the past year and going to counseling and whatnot, discussing why did this happen? Why did the officer not hear me? Why did he not take care of the situation when my daughter was endangered? It was because at that time, Timmy drove off. He then somehow switched spots very quickly with his witness, Jordan Mansfield, and she returned to the scene and dropped my daughter off right on the road. She didn't go into the driveway, nothing. He lived in Grand at the time, and I don't even know how he made it back to Newaygo where my sister and this incident occurred. So.
The video, Mom says, shows a child unbuckled, car door open, and a fast pull away en route to a wedding. She reports the officer declined action that day. 2 truths can coexist. 1, police discretion in the moment, and 2, family court standards later. Juvenile safety standards are stricter. Even if there's no ticket or arrest, judges can still weigh the behavior as unsafe parenting. Expect defense to challenge angles, continuity, or who was driving when. If admitted, judges look for patterns. Is this a one-off bad call or part of a larger instability story? Engagement cue. From what you heard, one-time lapse or recurring risk. Tell me why.
Okay.
After that incident, I did have meetings with his dad and stepmom, and I put in a PPO as well as a full custody motion. But at that time was when he was incarcerated. So they thought that my attempts for a PPO as well as full custody were simply because he's gone away in jail, she is trying to just get custody. But as you see in the video, I was scared for my child's life. I was scared for my life. My foot got hit, my arm got hit. There shouldn't have been any reason he made it to that wedding. But instead, the officer said, I'll talk to him in the morning. He has a wedding to attend. Luckily, that officer is now resigned and retired, because if I ever get rich, I wanted to badge him. There's no reason that situation occurred, and nothing happened.
Okay. Please continue.
So then, after that, fast forward to May. when we received the recommendation from friend of court for me to have sole physical custody and Timothy to have supervised visitations, I then, did you have a question about that?
Yeah, I had a question because that child did not look 7 years old or 8 years old. When did that incident occur?
She was a big girl. That was last year.
Really? Okay. She was 7.
Yep.
Okay.
Yep. My coworkers always say she's like 10, 12. That's how big she looks.
I'm sorry, but from that video, she looked a lot smaller. So that's why I was questioning when it happened. I apologize.
No, okay.
It's an observation. And I just wanted to kind of like, okay, when did that occur? I wanted to make sure you said when it occurred. I know you did. You've already testified to that. But I'm like, child looked a little small, but could have been the camera angle. All right, please proceed.
So then May, we received the friend of court recommendation stating that they do not think he was fit to have a split custody with me. They wanted me to have sole physical custody and him have supervised visitations. At that time, I was cordial in talking with Jordan, and I expressed that that was what the friend of court wanted for me to have. She got angry and did not respond to me for a month and a half. And I was like, okay, bad that you don't feel good for me. I get it. You have to have 50-50 with him, but I'm making movements to hopefully get him counseling so that these changes that he's stating that he's made are actual changes and that they stick. Back in February, when we spoke with the friend of court, in the meeting, he even stated, apologies, it may not have been exactly February, but when we met with the friend of court and we were talking about the drug usage, he had initially tried stating that it was initial drug usage in January. But then as the meeting went on, he admitted that it was actually a relapse.
Where we land today. Mom asks for sole physical custody and tighter safety rails, pointing to May 23 incarceration, a January 24 assault she says the child saw, and a February 24 arrest tied to a protective order. Dad says he's clean, wants alternating weekends plus summers, and acknowledges distance makes week on, week off unrealistic. Procedurally, missing subpoenas hurt corroboration, but the video, if admitted, could weigh on safety. The judge signals a likely path. Start parenting time conservatively, verify sobriety, and, per the Supreme Court, meet with the child before issuing orders. If you found this case as shocking as we did, hit like, drop your verdict in the comments, and subscribe for more professional courtroom breakdowns every week. Share this with someone who needs to see how procedure and proof shape outcomes in family court.